Hi, and welcome to a very, very late night edition of United, a podcast for change. I am Lori, your host, and I couldn't sleep. So I've been trying to pull the copy of the order denying the stay in the DC case against former President Donald Trump in relation to the gag order. And PACER, which is the court system, the electronic filing system, where the order was, has been a pain in the balls for the past 4 hours. So I finally got the order and I said, you know what? I can't sleep. So we're just going to go over it. And the first thing that I'm going to bring up, the first thing that I would like to do is to thank all of the new subscribers. There's been 83 in the past couple weeks, which has just been awesome. A lot of comments, a lot of interaction, and I'm very, very grateful for it and very, very appreciative. So the first thing that I want to bring up is the actual stay order itself. I'm sorry, the gag order itself, to show kind of where we started. And this order was issued on, as you can see at the top, it was issued on October 17th. And this is the DC case that's brought by Special Prosecutor Jack Smith. The judge is Tanya Chutkan. So this is the partial gag order. And I say partial because, as you can see right here in this first paragraph, it says granted in part and denied in part. So when it's halvesies like that, it's, the common term, generally speaking, is partial. Just like in the New York case, there was a partial summary judgment order entered. And before we get started with this, I'd just like to say that everything that I'm saying is just opinion. Nothing that I'm saying should be construed as legal advice. I am not a licensed attorney. I am a paralegal and have been a paralegal for the past 26 years. So I understand the words that are on the page, but I offer no legal advice related to anything. If anything, I can, I'll speak, to things that I've seen throughout my work history and experience over the past, 2.5 decades. All right. So opinion in order, and this is from the judge. For the reasons set forth below, and during the hearing in this case on October 16th, 2023, the government's motion to ensure that extrajudicial statements do not prejudice these proceedings, ECF number 57, is granted in part and denied in part. And this motion to ensure extrajudicial statements, that just means statements outside of court. And ECF is the electronic case filing number. So if you look at the case docket, this particular motion that was filed by the government is listed as it's like docket entry number 57. So to continue, under binding Supreme Court precedent, this court must take such steps by rule and regulation that will protect its processes from prejudicial outside interferences. The case citation for this quote is Shepard v. Maxwell. The First Amendment does not override that obligation. Quote, freedom of discussion should be given the widest range compatible with the essential requirement of the fair and orderly administration of justice. But it must not be allowed to divert the trial from the very purpose of a court system to adjudicate controversies, both criminal and civil, in the calmness and solemnity of the courtroom according to legal procedures, end quote. and that's from Case Seattle Times Company v. Reinhardt. And then and wherever you see quotes in an order, they're taking language right from a prior ruling on like similar issues. So we have another quote. Although litigants do not surrender their First Amendment rights at the courthouse door, those rights may be subordinated to other interests that arise in this setting. For instance, on several occasions, this court has approved restriction on the communications of trial participants where necessary to ensure a fair trial for a criminal defendant. End quote. Here, alternative measures such as careful voir dire, jury sequestration, and cautionary jury instructions are sufficient to remedy only some of the potential prejudices that the government's motion seeks to address. And voir dire is just the, where they're picking the jury. And in order to safeguard the integrity of these proceedings, it is necessary to impose certain restrictions on public statements by interested parties. Undisputed testimony cited by the government demonstrates that when defendant, and whenever they say defendant, here they're talking about Donald Trump. So when defendant has publicly attacked individuals, including on matters related to this case, those individuals are consequently threatened and harassed. And then it refers back to the motion at different sections. Since his indictment, and even after the government filed the instant motion, defendant has continued to make similar statements attacking individuals involved in the judicial process, including potential witnesses, prosecutors, and court staff. Defendant has made those statements to national audiences using language communicating not merely that he believes the process to be illegitimate, but also that particular individuals involved in it are liars or thugs or deserve death. The court finds that such statements pose a significant and immediate risk that 1. Witnesses will be intimidated or otherwise unduly influenced by the prospect of being themselves targeted for harassment or threats, and 2. Attorneys, public servants, and other court staff will themselves become targets for threats and harassment. And that risk is largely irreversible in the age of the internet. Once an individual is publicly targeted, even revoking the offending statement may not abate the subsequent threats, harassment, or other intimidating effects during the pretrial, as well as the trial stages of this case. The defense's position that no limits may be placed on defendant's speech because he is engaged in a political campaign is untenable, and the cases it cites do not so hold. The circuit courts in both United States v. Brown and United States v. Ford recognize that First Amendment rights must yield to the imperative of a fair trial. Unlike the district courts in those cases, however, this court has found that even amidst his political campaign, defendant's statements pose sufficiently grave threats to the integrity of these proceedings that cannot be addressed by alternative means, and it has tailored its order to meet the force of those threats. Thus, limited restrictions on extrajudicial statements are justified here. The bottom line is that equal justice under law requires the equal treatment of criminal defendants. Defendants' presidential candidacy cannot excuse statements that would otherwise intolerably jeopardize these proceedings. Accordingly, and pursuant to Local Criminal Rule 57.7c, it is hereby ordered that all interested parties in this matter, including the parties and their counsel, are prohibited from making any public statements or directing others to make any public statements that target 1. The special counsel prosecuting this case or his staff, 2. Defense counsel or their staff, 3. Any of this court staff or other supporting personnel, or 4. Any reasonably foreseeable witness or the substance of their testimony. This order shall not be construed to prohibit defendant from making statements criticizing the government generally, including the current administration or the Department of Justice. Statements asserting that defendant is innocent of the charges against him or that his prosecution is politically motivated, or statements criticizing the campaign platforms or policies of defendant's current political rivals, such as former Vice President Pence. In addition, the sealed version of the government's motion to ensure that extrajudicial statements do not prejudice these proceedings is denied as moot. And this was entered on October 17th. Now, the line about Mike Pence and his campaign platforms or policies, this line is now moot because Pence has since suspended his presidential campaign. So next we are going to go to the Trump's attorney filed an appeal, or one of his attorneys filed an appeal of the gag order, and then there was like a procedural issue where the attorney that filed the notice of appeal wasn't admitted to the appellate court in order to file the appeal. So there's just some, he's got to get admitted, and and then that'll be all taken care of. There have been, there was a motion to stay filed. And with the appeal, a couple of days after the judge issued the gag order, she turned around and she administratively stayed the order herself, and then gave both sides the opportunity to submit briefs on their position. So this probably about 7:00 last night, since it's about 10 minutes to 4 in the morning, she entered this order where she's removing the stay. So we're going to go through this order next. On September 15th, 2023, the government filed a motion to ensure that extrajudicial statements do not prejudice these proceedings. Following a motion hearing on October 16th, and this is C transcript of motion hearing, electronic case filing number 103, hereinafter, and where you see, this, HR apostrophe GTR. When you see something like this in a court filing, it just means that every time from now on in the document that I'm, or that the judge is referring to the transcript of the motion hearing, it's just going to be like this abbreviation, this hearing TR. So when you're looking at it, you would say like, hereinafter hearing HR apostrophe GTR. So following a motion hearing on October 16th, 2023, the court prohibited the parties and counsel in this matter from making certain public statements. And then this references the order that I just read. Defendant has appealed that order and now moves for the court to stay the order during the pendency of that appeal. The court entered a temporary administrative stay of its order while the parties briefed the motion, but will now deny defendant's motion and lift the stay. And then we have a footnote. And so in the footnote, it says the government also asked the court to incorporate the order into defendant's conditions of release. And that request was in the response in opposition to the motion to stay. So Trump's attorneys filed a motion to stay pending the appeal, and the government filed a response. And in that response, they also asked that the gag order be made one of Trump's conditions for release. So like the reason why he's, not in jail waiting trial on this case. The court hereby denies that request without prejudice. Even assuming that request is procedurally proper, the court concludes that granting it is not necessary to effectively enforce the order at this time. So here, generally speaking, the judge is kind of saying like, hey, I see that you snuck that in there. Kind of not cool. But it does also say, hey, defense counsel, I'm not denying the request with prejudice, and with prejudice means that like they can't bring it up again. And using the language at this time, that's a big wink, wink, nudge, nudge to defense counsel that does hint or can hint that, making it a condition of release, making, the gag order condition of release isn't completely off the table. So, discussion. 4 factors guide the decision whether to stay an order pending appeal. 1, whether the stay applicant has made a strong showing that he is likely to succeed on the merits. 2, whether the applicant will be irreparably injured absent a stay. 3, whether issuance of the stay will substantially injure the other parties interested in the proceedings. And 4, where the public interest lies. The third and fourth factors merge when the government is the opposing party. Here, all the factors weigh against granting a stay. The first point, likelihood of success on the merits. Defendant has not made a strong showing that he is likely to succeed on the merits. And this is the merit for the motion to stay. As the court has explained, the First Amendment rights of participants in criminal proceedings must yield when necessary to the orderly administration of justice, a principle reflected in Supreme Court precedent, the federal rules of criminal procedure, and the local criminal rules. And what this section indicates is that it's, not uncommon for a judge to issue a gag order in a criminal case, in a civil case, and that this isn't the first time that this has happened, because the judge is referencing that the Supreme Court has case law on this, that the federal rules of criminal procedure allow it, local criminal rules allow it. And contrary to defendant's argument, the right to a fair trial is not his alone, but belongs also to the government and the public. And then that references Gentile versus State Bar of Nevada, emphasizing the state's interest in fair trials, and United States v. Tijerina, quote, the public has an overriding interest that justice be done in a controversy between the government and individuals, and has the right to demand and expect fair trials designed to end in just judgments. This objective may be thwarted unless an order against extrajudicial statements applies to all parties to a controversy. The concept of a fair trial applies both to the prosecution and the defense, end quote. So this is, again, language taken from this United States v. Tijerina case. Defendants' repeated appeals to broad First Amendment values therefore ignore that the court, pursuant to its obligations to protect the integrity of these proceedings, recognize those values, but in balancing them against the potential prejudice resulting from certain kinds of statements, found them outweighed. Defendant's other claims also disregard the record. To begin, he asserts that the court cited no evidence supported its findings of risks of harassment and witness intimidation, and the prosecution provided none. And when it says he, it means like Trump through his attorney. It's not that Trump typed up these motions. His attorneys did that, but, it'll refer to he, the defendant. So I'm not really going to refer to, the attorney. But, all right, so we'll pick up. But several times, the court and the government pointed to evidence causally linking certain kinds of statements with those risks, and defendant never disputed it. See hearing transcript at paragraph 67. The court, quote, when Mr. Trump has singled out certain people in public statements in the past, hasn't that led to them being threatened and harassed as demonstrated in the statements attached by the government? Mr. Lauro, who is one of Trump's attorneys, quote, Your Honor, that's totally irrelevant, end quote. The court, quote, and the government's motion cites several of them who averred in the kinds of statements that you've asked for under oath that threats and harassment toward them had increased significantly as a result of Mr. Trump's statements about them, end quote. And then an additional quote, undisputed testimony cited by the government demonstrates that when defendant has publicly attacked individuals, including on matters related to this case, those individuals are consequently threatened and harassed. And see also another filing, which is number 60 on the docket, failing to dispute or even discuss the testimony cited by the government. The evidence is in the record. Defendant simply fails to acknowledge it. And somewhere I missed up here, I missed a footnote. So this footnote is in reference to the motion to stay filed by Trump's attorneys. Defendant's motion argues that his speech restrictions are inconsistent with the, quote, right of listeners to perceive President Trump's message, end quote, motion to stay at 15. Defendant did not squarely raise that argument in his opposition brief to the government's original motion. The closest he came to identifying any authority for it was an unrelated see also citation to United States v. Ford, a case that he now quotes to support his right of listeners argument. Compare docket entry number 60 at 5 with motion to stay at 16. But the court expressly addressed and distinguished that case. In any event, that's usually language in filings and orders where it's like, yeah, like whatever, dude. But anyway, in any event, the argument does not alter the fundamental principle that First Amendment rights, whether those of the speaker or the listener, may be curtailed to preclude statements that pose sufficiently grave threats to the integrity of judicial proceedings. And now we're continuing with the judge's order. Likewise, defendant claims that the court gave no meaningful consideration to alternative, less restrictive measures, including a narrower order. Again, the record flatly contradicts that claim. During the motion hearing, the court questioned whether defendant's existing speech restrictions, such as his conditions of release, would adequately prevent the potential dangers to these proceedings. And there's another reference to the hearing transcript. And it looks like 3 different sections of the hearing transcript where this issue is covered. The court also considered whether alternative measures could prevent those harms, and in fact concluded that they could, with respect to certain kinds of statements, such as those disparaging the District of Columbia. Accordingly, the court denied the government's motion in those respects. But the court explained that alternative measures would not sufficiently mitigate the risks flowing from other kinds of statements, such as those targeting reasonably foreseeable witnesses. quote, here, alternative measures such as careful voir dire, jury sequestration, and cautionary jury instructions are sufficient to remedy only some of the potential prejudices that the government's motion seeks to address, end quote. And then there's another reference noting that the risk created by certain statements would be irreversible. And then again, quote, this court has, and this is quoting from the gag order, this court has found that even amidst his political campaign, defendant's statements pose sufficiently grave threats to the integrity of these proceedings that cannot be addressed by alternative means, and it has tailored its order to meet the force of those threats, end quote. The court thus tailored its order to prohibit statements only where less restrictive measures would be inadequate. Defendant's final claim is that the order is unconstitutionally vague for various reasons, none of which withstand scrutiny. First, defendant quotes Merriam-Webster Online's definition of interested to conclude that the term interested parties could include everyone affected by or involved in the case. But interested party is a well-established legal term of art, meaning anyone who both is directly interested in a lawsuit and has a right to control their proceedings, make a defense, or appeal from an adverse judgment. And so she sees his Merriam-Webster definition and raises him the Black's Law Dictionary definition, which would, no pun intended, trump the common language of interested. And it's really grasping at straws a little bit, and this is just my opinion, to nitpick an order to this extent. I mean, I read the order. It was pretty straightforward as to, it's basically just don't talk shit about people. And it's for all of the parties. It's not just Trump that has the gag order, although that's all that, anybody's talking about, or anyone seems to be interested in, but it also means that the prosecutor can't go and talk shit about anyone. The other attorneys, the defense counsel can't go and talk shit about anyone. It's a gag order on all parties. I should have kept reading. The order confirmed that scope, defining the term as including the parties and their counsel. And, so it points to the gag order at 3. See also, the hearing transcript. So this is being covered in multiple places. And with the hearing transcripts, it's stating that the written order would apply to the parties and their counsel. There is no meaningful basis to interpret interested parties as covering anyone else. And this is a very nice way of the judge telling counsel, stop being a dick and arguing semantics. Come on. Second, defendant focuses on the prohibition of, quote, targeting certain individuals, again, quoting various dictionary definitions, to assert that targeting could include not only identifying those individuals, but also attacking them, subjecting them to ridicule or criticism, or otherwise attempting to affect them. But, quote, restating a dictionary to, quote, search for every facet of relevant terms is not a proper vagueness inquiry. And that's from United States v. Bronstein. Quote, rather, a statute is unconstitutionally vague if, applying the rules for interpreting legal texts, its meaning specifies no standard of conduct at all. And that's quoting Coates v. City of Cincinnati. And a cardinal rule of interpretation is that context matters. A word is known by the company it keeps. Quoting Jarecki v. G.D. Searle and Company. The motion hearing and corresponding order provides substantial context for and examples of the kinds of targeting statements that could result in significant and immediate risks to the integrity of these proceedings. Indeed, the court identified that depending upon their context, statements matching each of the definitions defendant proffers for the term target could pose such risks. See hearing transcript at 50 to 54. Risks associated with publicly identifying court staff. Also at 41 to 43, risk associated with attacking prosecutors. 59 to 60, risks associated with criticizing potential witnesses. 13 to 14, risks associated with attempting to affect potential witnesses' testimony, even using praise rather than criticism. Defense counsel also repeatedly relied on it's 4 o'clock in the morning. I apologize for being punchy. Defense counsel also repeatedly relied on context to distinguish permissible from impermissible statements. And then this is also from the transcript where the court says, quote, next hypothetical, which is now quoting a statement. Bill Barr is a smart guy, but he better learn to keep his mouth shut. Permissible or an attempt to obstruct justice or intimidate a witness? And then Mr. Lauro says, it depends on the context. If it happened the day before Bill Barr testified at trial, that might be impermissible. End quote. A term is not rendered unconstitutionally vague because it does not mean the same thing to all people all the time everywhere. And this is also from Bronstein, quoting Roth v. United States. The court's order and the motion hearings record sufficiently clarify the meaning of targeting to provide fair notice of the kinds of statements understood in context that it prohibits. Two of defendant's social media posts since the order's entry illustrate the comprehensible difference between the statements it permits and those it prescribes. First, on October 20th, 2023, after the order was entered, but before it was administratively stayed, defendant stated, does anyone notice that the election rigging Biden administration never goes after the riggers, but only after those that want to catch and expose the rigging dogs? Massive information and 100% evidence will be made available during the corrupt trials started by our political opponent. We will never let 2020 happen again. Look at the result. Our country is being destroyed. MAGA. End quote. And the judge continues. The statement asserts that defendant is innocent, that his prosecution is politically motivated, and that the Biden administration is corrupt. It does not violate the order's prohibition of targeting certain individuals. In fact, the order expressly permits such assertions. By contrast, on October 24th, 2023, after the order was administratively stayed, defendant stated, quote, I don't think Mark Meadows would lie about the rigged and stolen 2020 presidential election merely for getting immunity against persecution by deranged prosecutor Jack Smith. But when you really think about it, after being hounded like a dog for 3 years, told you'll be going to jail for the rest of your life, your money and your family will be forever gone, and we're not at all interested in exposing those that did the rigging. If you say bad things about that terrible monster Donald J. Trump, we won't put you in prison. You can keep your family and your wealth, and perhaps if you can make up some really horrible stuff about him, we may very well erect a statue of you in the middle of our decaying and now very violent capital, Washington, D.C. Some people would make that deal, but they are weaklings and cowards and so bad for the future of our failing nation. I don't think that Mark Meadows is one of them, but who really knows? Make America great again. And then we have a footnote at 4, and that where it's referencing the Truth Social post. The Judge continues, this statement would almost certainly violate the order under any reasonable definition of targeting. And then we have another footnote at 5. It says, because of the administrative stay on the order, this statement is not before the court. Before concluding that any statement violated the order, the court would afford the parties an opportunity to provide their positions on the statement's meaning and permissibility. So, generally speaking, when you see language that says not before the court, that just means that like the judge is acknowledging that when you posted this, there was a stay on the gag order. So, I don't formally see this. And, before the judge would conclude whether or not that statement would violate the order, she's not going to do that here. If she was going to do that, if there was no stay in effect, she would give the parties the opportunity to kind of, explain themselves. Yes, there is the First Amendment, but the thing is, Mark Meadows is potentially a witness in the DC case. And you can't mess with witnesses. I mean, that's nothing new. Like, neither side can mess with witnesses. The judge continues, indeed, defendant appears to concede as much in the reply in support of the motion to stay. Quote, if the gag order had been in effect, President Trump would have been unable to make the statement. End quote. And for good reason. The statement singles out a foreseeable witness for purposes of characterizing his potentially unfavorable testimony as a lie made up to secure immunity, and attacks him as a weakling and coward if he provides that unfavorable testimony. An attack that could readily be interpreted as an attempt to influence or prevent the witness's participation in this case. The plain distinctions between this statement and the prior one, apparent to the court and both parties, demonstrate that far from being arbitrary or standardless, the order's prohibition on targeting statements can be straightforwardly understood and applied. Generally speaking, I would agree. If the judge issues an order and a gag order that lays out what you can and cannot say, and then you do a post where you follow along with the terms of the order, and then as soon as there's a stay put in place, you go right back to the shit talking. You really can't play I don't know what the order means. The order is not clear. No, clearly you know what the order means. You understand the context. You understand what you can and cannot say. And again, this is nothing new. Judges issue gag orders, not in every single case, but it's not rare. and a gag order, it stops speech. It's the whole gag. That's why it's a gag order, because it effectively, puts a gag in someone's mouth. And if you ever watch cases online or live streams or on TV or just wherever where you're watching actual court proceedings, you will also see that it's you can't talk to jurors. So could somebody argue that type of restriction goes against a person's right to free speech and a right to assembly. I mean, it's you have to weigh rights. You have to weigh everyone's rights. It's not just the defendant's rights, and the defendant, Trump in this case, he is entitled to a fair trial. But then, so is the court. You can't dick around with witnesses or, potential jurors or actual jurors. Judges all across the country in all different kinds of cases where there is a jury and they're not sequestered, which means they get to go home when court's done for the day. If the trial's still going on, judges will routinely say, don't talk about the case, don't go on social media, don't watch TV, don't read the newspapers, and that is limiting their speech. So, people run around going, oh, First Amendment. But the Supreme Court has ruled that you're allowed to, put reasonable restrictions where it's warranted. And the Constitution, it's you've got the right to free speech, but then the Constitution also allows for the right to a fair trial. So you have competing constitutional rights, and the judge's gag order in this DC case, she outlined it. It was like you just can't talk shit about the people related to the case. You want to rag on Biden or say you're innocent, rag on the DOJ, fair game. But just keep everyone related to the case's names out of your mouth. So to continue, defendants' other assertions of vagueness boiled down to similar objections that deciding whether a statement violates the order will necessarily be a fact-bound inquiry. He contends that it may at times be difficult to tell whether an individual is a reasonably foreseeable witness or to distinguish proclamations of innocence from attacks on prosecutors or witnesses. But even assuming that is true, it does not follow that, quote, men of common intelligence must necessarily guess at the meaning, end quote, of the order's prohibitions. And that is from Hines v. Mayor of Oradell. It is a basic mistake to derive vagueness from the mere fact that closed cases can be envisioned. Closed cases can be imagined under virtually any prohibition, and that is from United States v. Williams. If a party or their counsel makes a statement that may have violated the order, the court will assess its substance and context. The fact that it needs to do so with special care in closed cases does not render the underlying order unconstitutionally vague. Consequently, defendant has failed to make a strong showing that he is likely to succeed on the merits of his appeal. Next section, remaining factors. The remaining factors also counsel against a stay. Defendant's brief arguments on each rely entirely on the premise that the court's order violated his First Amendment rights. See motion to stay at 31. Quote, a showing of likelihood of success on a First Amendment claim necessarily establishes irreparable injury, end quote. Quote, as for the balancing of harms in the public interest, the demonstration of an ongoing violation of the First Amendment rights dictates that a stay should be entered, end quote. Having rejected that premise, the court reaches the opposite conclusions. Where, quote, there is no showing of a likelihood of success on the merits, end quote, of a First Amendment claim, there is no irreparable injury or public interest favoring a stay. And that is from Archdiocese of Washington v. Washington Metro Area Transit Authority. To the contrary, few, if any, interests under the Constitution are more fundamental than the right to a fair trial by impartial jurors, and an outcome affected by extrajudicial statements would violate that fundamental right, end quote. As discussed above, in the order and during the motion hearing, the court finds that the public interest in the orderly administration of this case requires the order's limitations on such statements. For these reasons, defendant's motion to stay at docket number 110 is hereby denied, and the administrative stay imposed by the court's October 20th, 2023 minute order is hereby lifted. And that was again entered yesterday, October 29th. And so those are the orders. Reading orders can suck. Especially when you get into like what is the judge saying as opposed to, where they're citing case law. There's different court cases. That's what it's called. It's case law. And you will see in countless orders where, if a judge has an argument, or a prior case that backs up what they're saying in, the case they're ruling on, they'll bring that language into their opinion to show like, hey, I'm not setting precedent. I'm not making new stuff up. It's basically bringing the receipts, and that's what the judge is just doing in this order. And again, doesn't say that he can't talk about the case. He can't. He can. He can say that he's innocent. He can say that it's bullshit. He can, talk shit about Biden all he wants. He can talk shit about the DOJ all he wants. He just can't say things about the parties, their attorneys, court staff, or potential witnesses. And that is nothing new for a criminal defendant. Yes, it gets a little wonky because he's also the former president and he's also a current presidential candidate. It does make it weird, but these things don't necessarily supersede the constitutional right to a fair trial. And, where there are people screaming and hollering about, 2 tiers of justice and, the DOJ, the FBI, like they're corrupt and, blah, blah. And, everybody's entitled to their opinion. At the same time, when the court's trying to do what's right for the rule of law and for the Constitution, like they're treating Trump just like every other defendant. You can kind of see where, because he's rich and he's a former president and he's a presidential candidate, where he does get a little bit of, different treatment because there are, if this was the average Joe, they could very well be sitting in jail waiting for their trial date. And Trump's not. He's out. He's got no restrictions on where he can travel to. And, it's just don't talk shit about the parties to the case, the attorneys, the staff, witnesses. It's normal. But those are the orders. And I'm sure there will be more to come. Today is going to be an interesting day because there is supposed to be the start of either a hearing or some type of trial on another case filed. This is a Colorado case, and it's filed by it's like a citizen organization against Trump and the Colorado Secretary of State. and I believe like the Colorado like Republican committee has intervened, and that just means that they weren't original parties to the case. They asked to be a party, like they asked the court for the okay to be a party in the case because they have an interest in the outcome. Here we go. Interested parties, like referenced in the order. Because this case in Colorado is one that is seeking to have Trump declared ineligible to be on the ballot in Colorado, pursuant to the 14th Amendment, Section 3, that talks about where if you've, if you're an elected official or certain elected officials or an officer of the United States and you've taken an oath to, support the Constitution, and then you engage in insurrection or you help people engaging in insurrection, then you're beat. You can no longer hold, you can't hold public office unless like 2/3 of Congress says it's okay, like they remove the restriction, which that's not going to happen because right now the House is practically 50-50. The Senate, I think, is 51-49. So there's no way that 2/3 of Congress is going to vote, because like the Democrats wouldn't vote for it. So that trial in that case is supposed to start at some point today. And it looks, in that case, it looks like Trump had filed, for like an emergency stay. Where is the Trump docket? Let's see. Yeah, a request was sent to the Colorado Supreme Court to stay the trial that's supposed to start today. And it might just be another hearing. It could be the start of the trial. That is going to get interesting. It does look like it may be aired, but that, the requests were granted allowing for certain like news stations to have the okay. They're going to set up like a pool camera, and then they'll have to work out like who's going to air what and how, just how it's going to work. So that's supposed to start today. I'm going to check that out, and there might be, I might do like a live stream of that trial, but I'm probably going to watch a little bit of it first to see if there's anything interesting, because I imagine that most of it is going to be dry AF. And yeah, no. So I'll probably check some out. But if anyone has any questions about the order or any of the cases that are going on, feel free to add a comment. And again, I want to thank all of the new subscribers. I very much appreciate your presence. All the uptick in views, even on like older videos. It's just really, really appreciated. I've been excited every day. When I come in to look, there's more subscribers, and it's really been wonderful to see. So just know that I appreciate you. And yeah, if anybody has any questions about anything else, if there are any topics that you would like covered, pop a comment on a video and just let me know. I do try to respond to all of the comments, even if it's just thanking the person for commenting. But that's about it for right now. So it's now 4:30 in the morning. Maybe I'll get some sleep. Probably not. I hope everyone else has a great night. But yeah, till next time.